It's my pleasure to welcome and to wish you all welcome to our 25-year celebration of modern competition law, or as Michelle Wilkie says, postmodern competition law. We also celebrate, when we celebrate 25 years of modern competition law in South Africa, we also celebrate the E&S Competition Department and 25 years of its existence. So I'm just going to pause there for a moment, and if you will indulge me, we have been reminiscing about our journey over the past 25 years, and it's lovely to see so many familiar faces here, and it's lovely to remember the journeys that we have walked over the past 25 years. It has certainly been interesting, exciting, never boring. That's not something that one can say about competition law and the practice in the field. So the competition department, the E&S competition department, was started in 1999 as the Competition Act came into effect by the legendary Lee Mendelsohn. She's unfortunately not here yet. She will join us a little bit later, she said. But and she was the head of the competition department until she was stolen away by our management, to assist at that level, and her role was then taken over by Jocelyn Katz, sitting to my right, and she needs no introduction. Now, the E&S competition department has been at the forefront of the developments in the field, with some of you here in the room, with our partners, advocates, economists, our counterparties, and then the Competition Commission and Competition Tribunal in many instances. And you can basically track the Competition Department's history and development with the development of competition law, or modern competition law in South Africa. And the reason I say modern competition law is because there was competition law. People forget that before 1998 there was a Competition Act, the Maintenance and Promotion of Competition Act. Michael will speak a little bit about that. So it wasn't a new thing for the South African economy, it's just the way in which it has been done that has been a total overhaul of the regime. So if we go back to the mid-1990s, and I'm sure Michael and Davis will take us through that as well, why we have the Competition Act the way we have it now, why we have these modern independent competition institutions, the Competition Commission, we have a representative from the Commission, Competition Tribunal, we have a representative, and then the Competition Appeal Court. Why these institutions were developed the way that they are, and we'll delve into that a little bit on the panel. And the panel will also talk about how different competition law is in South Africa versus other countries. And what is heartening is to see that other countries, other legislatures are starting to follow in the footsteps of South African competition policymakers. Now, I think none of you need to be told this, but very basically, there are two broad tools in competition law. One is mergers to prevent anti-competitive market structures from arising, and then to regulate behavior, we have prohibited practices. And prohibited practices dealing with cartels, with vertical restrictive practices, and then with abuses of dominance. And abuses of dominance being quite an important tool in the South African economy. In the early days of the competition authorities, we would say the first 10 years or so, focus was very much on mergers work. And not because, and Wanda will help me here because she was also at the Competition Commission in the early days, not out of choice really, but because of the way in which the Act and the regulations were structured. Mergers have very tight timelines, it's various prohibited practices have very long timelines. So when you get a merger, you have to deal with it. You can't think too much about it, and particularly in the earlier days, and I'm looking there and I'm seeing Martin van Werven also walked the journey with us at the Competition Commission. You just had to get on with it. And I'm sure we made lots of mistakes during our period there. We learned a lot, certainly. And the level of sophistication of the Competition Commission now emerges is, I think Martin and I would just say, well, we did what we could at the time. But there is certainly an increase in the level of sophistication in the analysis that is being done by the competition authorities now, as one would expect with 25 years of knowledge and practice behind it. Things were a bit slower on the prohibited practice side. There were a couple of cases that were taken on, abuse cases. Some of them overturned, some of them still standing, because the AID test still stands today in terms of exclusionary acts. But slowly but surely more activity happening in that area. And I think tomorrow is also going to take us through a little bit of the history of the development of these cases. What we have seen since then is, however, significant amendments. I think within the first 2 years of the Competition Act, there were a number of amendments. They were more practical tweaks to the Competition Act, but we saw significant, not overhaul, but changes. The set of 2009 amendments that only came into effect in 2016, only some of them, introducing formal market inquiries and then criminalisation of cartel conduct, the outcome of which we have not yet seen in South Africa. And then the 2019 amendments that strengthened the powers of the Commission in terms of market inquiries, introduced buy-power provisions, etc., but very, very importantly introduced a fifth factor to be taken into consideration in the merger's public interest test. And our panel will talk about that as well. I've mentioned, before I step down, I've mentioned that we have been reminiscing here at DNS about our journey, and I would like to invite you to go to our website. We have shot a number of videos, and we had very thoughtful interviews with Dave Lewis, the first chairperson of the Competition Tribunal. It's a half-an-hour interview, well, actually a dialogue between him and Jocelyn. Lovely old stories, reminiscing also about the start of the competition authorities, and also the approach that was taken during the first period. There's also a lovely interview with David Untalto. There's a very practical discussion between our colleagues in the competition department, Piwe and Ziza, on dawn raids, and then also a discussion on COMESA merger control. There's a Meet the Team video, and the most popular one of all the videos is the bloopers. It is worth having a look, even if you just go and look at the bloopers. I watch it once a day. It makes me feel much better about myself. Okay, so please have a look. Please celebrate this journey with us, and thank you so much for being here today. I'm quickly going to introduce our panelists, which I think don't really need much introduction, but we have Judge Dennis Davis. He's the first judge president of the Competition Appeal Court. In addition to an illustrious legal career and a television career, he was a member of the drafting team of the Competition Act, shares that with Michael as well, and the Companies Act of 2008, shares that with Michael as well. He and Michael have walked a number of roads together because he was also a member of the Tax Commission into tax structure, and then he chaired his own tax commission in 2013 to 2018. He had served as the judge president of the Competition Appeal Court for 20 years, from 2000 to 2020, and then was in 2023 recalled to serve, and that is where he is still, and we're very glad and happy to have him with his insights and experience. The next person on our panel is Mondo Mazwai. Mondo began her career at Cheadle Thompson and Hayes & Attorneys, and she joined the Competition Commission from the very start. So she was there in 1999 when the doors opened. She was first in the Mergers and Acquisitions Division. As I mentioned, the development in the mergers and acquisitions field was much faster than in the other divisions. And I think, Mondo, if I recall correctly, around about 2003, you were transferred to go and pick up the pace in the enforcement division, which she then did for a while. Thereafter, she was appointed as the Chief Legal Counsel, and she was also an acting Deputy Commissioner. She then made a huge mistake by joining a law firm down the road. Just kidding, Mondo. And since 2013, she has been a member of the tribunal and has been and was appointed chair in August 2019 by President Cyril Ramaphosa. So Mondo, welcome. Thank you. Tamara, first thing about Tamara, she's very modest. So you know, she asked me to use a very short blurb for her introduction. But thank you, Tamara, also for joining us. She's an economist. She has more than 20 years' experience in the public and private sectors. She's the divisional manager of mergers and acquisitions at the Competition Commission, and she's held that position since 2019, which I think probably makes you the longest-serving manager of mergers ever. Okay, so well done. She's got tenacity. Then Michael Katz. Michael, we have the pleasure of seeing Michael those days, so to us it's an introduction to those of you who have been under a rock for the last 50 years. We introduce you to Michael. He's the chairman here at ENS. He specializes in corporate and commercial law and advising on M&A, competition law, tax law, privatization, deregulation, project finance and recourse financing, public and private partnerships, banking and financial markets. Can I say, Jocelyn, that he's the Dumbledore of law in South Africa? That's our Michael. You know, he's a very prominent figure in the legal field in South Africa. I could talk, Michael, for another 30 minutes, but I'm not going to. But I will just say that Michael was intricately involved in the drafting of the Competition Act and the process of the drafting of the Competition Act. And he'll talk about that in a little bit. And then also the CATS Commission, the Commission of Inquiry into the Tax System that was launched shortly after the democratization of South Africa. Then Jocelyn, the best boss in the world. She is an executive here and head of the competition antitrust practice here at ENS. Jocelyn does everything. She does mergers, she does the restrictive practices, market inquiries. She is the doyenne of the multinational filing, particularly across the rest of Africa. If you have a complex matter that you need to juggle 20 balls, Jocelyn's your person. So over to you.
The Dumbledore of law, but I do. As the Dumbledore of law, but anyway, I do. Welcome everybody, it's so lovely to have you here. So the aim of this panel discussion is really the culmination of what we've been doing throughout the year, and that is sort of with this great sense of nostalgia. We've been taking a trip down memory lane and reminiscing about our journey. You know, a lot has happened over the last 25 years in this space. And so we have this esteemed panel to answer a wide range of questions. I'm going to try and be quite strict and keep to time so that we can reserve a little bit of time at the end for a very small number of questions from the audience if we can fit it in. I'm sure a number of you will have things to ask, so we'll try and fit that in. And I think to kick us off, Michael, I'm going to go back to the beginning, right? So you practiced in competition law under the Maintenance and Promotion of Competition Act. You continued in the new era with the Modern Competition Act in 1998. You were also involved in the design and drafting of the new Competition Act. Do you have an interesting story to share with us about this journey?
It was a long journey. My interest in competition law started when I read the report of the Mouton Commission, which led to the previous act. But under the old dispensation, you had to know what the commercial reality was in South Africa. And that was described, I was at a dinner when Donald Gordon opened Liberty Life building in Bromfontein. And he said, you'll see the Johannesburg Stock Exchange, 90% of it will be owned by 6 groups. Remgro, Anglo-American, Anglo-Vol, Liberty Life, Old Mutual and Sanlam. And that was because there were very strict exchange controls in South Africa. The institutions had vast pools of savings. They had to invest it for the benefit of their beneficiaries, and they were just having to buy up everything that moved. So that was the background to practicing law under the old competition law, under the old dispensation. And I come back to it, how decisive that was in the formulation of the new act. But just 2 interesting stories. In the old dispensation, it was very informal. When you had a merger, there were no pre-notifications, but you went to see the chairman and made your case and took your key witness with you, and you got dispensation. So on a very major merger, I took the CEO with me. We had to see the chairman of the board. And I said to him, you're our witness, I'm going to lead you. Just keep eye contact with me and just answer the questions, nothing more. And he was a star witness, went swimmingly well. End of the session, the chairman said, yes, I'll clear it. Michael, I'll send you the certificate soon after this. Up gets the witness and says to me, thank God we've now acquired this company, the price war's over. To which the chairman said, sit, let's talk. And then one of the last ones, or it could have been in the beginning of the new one, there was a merger of Rembrandt and British American Tobacco, and I had to go and argue it. It was 94% of the market. And I said to the chair, my understanding of antitrust law and mergers is that you don't want prices to go up post the merger, and you don't want to undermine consumer choice. That's the case. Would you be upset after this merger if the price of cigarettes went up? Would you be upset if consumers had fewer brands of cigarettes to buy? Common cause, no, merger cleared. So that was the beginning or the end of the old dispensation, the beginning of the new one.
Yeah. Things have changed somewhat since then, which I'm sure we'll get into. But Michael, just to stay with you for a moment, why did South Africa need to overhaul the regime in '98? And what stands out to you as the most important differences between the old act and the new?
Okay, this is an interesting question. I've described what the degree of concentration was when the new regime took office in 1994. When I was asked by President Mandela and Derek Keys, the Minister of Finance, to chair the Tax Commission, they said to me, Michael, the 2 most important things we have to do in South Africa is get a proper tax system, recognizing the new dispensation of the country, and get a proper antitrust system. And I'll never forget, he said, there's a budget in 2 weeks' time. We've got to announce our tax policy. We don't have one. Would you chair a commission? And I reflected again and again what he said about antitrust. So why was it so necessary? South Africa was hugely concentrated. And not only was that bad economically, but it also had a political dimension. That concentration arose because of the apartheid regime, the economic power was concentrated in the hands of the preceding players, and the new regime, I remember talking to Alec Irwin, Trevor Manuel, was determined to change that there should be a proper correlation between the demography and the ownership of assets. And in the first meeting I had with Alec and Alistair Raters, they said, we want a provision on trust busting. We want to be able to unbundle existing conglomerates. So that was really the background to why things needed to be changed, economically and politically. So what were the major changes? The rest of the panel will give you, but I think the first one, and it was right, was the three-tier structure of competition, the competition authorities. The Commission as investigator, the Tribunal as referee, and the Competition Appeal Court as the right of appeal there. Also, what was very important was to depoliticize it. Independence. In the old regime, the minister had to approve, and in this new dispensation with this three-tier, there was no political position in it at all, and we'll come back to that again and again. I think this is one of the jewels of our new structure. It is totally independent of politicians. There was no pre-merger notification, no longer ex parte. There was now discovery. Public interest became a structured factor. And talking about public interest, in my first discussions, and Dennis, others will have, South Africa was the first jurisdiction to have the dual test, adverse impact on competition, public interest. But in those early discussions that I was part of, public interest was regarded as a redeeming factor. Yes, it may be anti-competitive, but it could be redeemed by public interest. That's swung right the other way around today. And then there were no prohibitions on specified anti-competitive cartels, etc. Also drew on a lot of the learnings of foreign jurisdictions, and it was to South Africa's credit that in a developing economy, it was able to craft so many of the jurisprudence of foreign jurisdictions. There was also a new culture. As an M&A lawyer, the conduct of an M&A practice changed dramatically after the new dispensation, dramatically and very rapidly. And you had protection of privilege, the economists would have to route everything through lawyers. It was just a whole new dispensation. I want to just make one last comment. I think that it's been an absolute wonder how well this worked. In no time, and a whole new dispensation based on some of the most sophisticated regimes in the world. And I think that was largely attributable to the role players at the time, and in particular to David Lewis. David was a remarkable chairman of the tribunal, and I think that the jurisprudence that came from that was quite remarkable, and all the role players in the competition regime really made it work. Just one last comment on David. David wasn't a lawyer. I think he did a remarkable job of having properly controlled but not getting it over-lawyered. David had a problem with over-lawyering. Just two very quick stories. On the Sasol engine merger, our counsel was Fani Celia, and David used to sit at the table and he would munch his ball pen, swivel around look at the roof, and Fani said, no, Michael, I can't operate in this room like this. But David was remarkable. He got the right judgment, even those against me, for the right reasons, but he didn't want it over-lawyered. One last story on David, some of you probably knew. There was a counsel leading two witnesses simultaneously. David was getting irritable. Eventually he said to the counsel, stop it, I can't carry on with this Punch and Judy show. So it was a very remarkable time, and it was a great transition.
Thanks, Michael. A lot to unpack there, but I think we'll probably cover much of it as we go through. But yes, I do urge you, as Lizelle mentioned, to watch that discussion that I had with Dave, where he does touch on some of these things. It really was a fascinating time. But Monty, I'm going to move on to you, if I may. You were part of the very first mergers and acquisitions team at the Commission in '99. I'm sure you have some interesting origin stories for us to share.
Yes, good morning everybody, and thank you for the invitation to the Edward and Sonenberg team. It's good to be in an environment for a change where we are not in a hearing and just having a conversation, so it's good to be here. I did join the Commission in September after I had done a couple of years as an associate at Tito Thompson & Hazel. And one of the things that I remember about the time then was the excitement and the hope that was felt all around at the time, particularly after 1994 and the new democracy and this legislation that was going to be opening up the economy, and we were going to be a part of that change. And one of the earlier things that I recall specifically, which is where the learning happened, as you know, with mergers, you have to determine whether the merger is notifiable and if there's a change of control. And one of the earlier cases I remember vividly, and when Nathan was involved in it, and Michael Katz was in it, and we had to debate about whether the merger was notifiable because of the thresholds at the time. I mean, the practical experience of actually now reading the Act and saying, okay, on the acquiring side, how far do you go down or up to check the notifiability? And on the target side, if it's a part of a business, how do you calculate those things? So I remember that discussion, which was probably one of the earlier decisions that we dealt with, and Michael was on the other side. In the end, we both agreed that the transaction was notifiable, and we went about doing the merger assessment. Fortunately, it didn't have any competition issues, and so that was the first real practical experience. We also then had a couple of other mergers that were intermediate mergers, and some of them didn't make it to the tribunal, and they'll be lesser known. But I remember one with Lizelle. She was at the Commission at the time as well. And I think we both agreed that it would have been a steel drum case, which was prohibited because it was going to substantially prevent or lessen competition, so it was purely on competition grounds. And Lizelle and I had to write the reasons for the prohibition, something we'd never done before. What I remember about it was just sitting with that piece of legislation, looking at Section 12 and going through each of the elements. And the learning from that was really the interface between competition law and economics, because she was an economist, I'm a lawyer, and we had to kind of figure out how we balance the two. I mean, it's interesting that Michael says David Lewis was not a lawyer. I think it's important to remember that competition law is economics law. And when you assess a merger, you have to get involved in the competition assessment of the cases. One of the examples that later came to bear, and we'll probably come back to it later, which shows how economics is really the fundamental assessment. And maybe the interpretation of the law is secondary, I might even say, is the Babelefi case that we had later on, when we fast forward now to the COVID period, where we really had to deal with the context of the case, where the law says 5% market share is not really dominance. How can you even conceive of it? But the economic assessment then does that says, where's the economic market power in this instance? And the definition of the Act does say what market power is, and so on and so on. And so I just say that to say, Gisela and I started our learning and engagement on how the interface between competition law and economics works. And we were never overturned on that because it never went to the tribunal to be appealed, that intermediate measure. And then one final point is really one of the things Michael also talked about is the credibility of the institutions. At the Commission, for at least the first 2 years when we were there, we had colleagues from the Federal Trade Commission in the US, we had colleagues from the Department of Justice in the US, we had colleagues from the Norwegian Competition Authority. So the first 2 years of the Competition Authority's existence was really capacity building, where we had these people, both lawyers and economists throughout, helping us to build capacity to learn the area, which was fairly new. And that has really stood us in good stead because we have been able to, 25 years later, be applauded even by those peers that started with us at the beginning, saying, you have built credible institutions, you have adhered to the rule of law, there is transparency in what you do, and that's, I think, very commendable. I remember that some of the investigations that we were doing, to Michael's point about just visiting the board and presenting the case, and then discover afterwards that there was going to be a price war, or the end of a price war. Here with the institutions, and what we learned with the DOJ colleagues and the FTC colleagues was sitting in meeting rooms with captains of industry, asking them questions about their mergers. And we had the benefit of having the people that had done competition law for over 100 years help us ask the right questions, learn how to deal with those captains of industry who had never had to be asked questions like that and would probably appear in the manner that Michael was describing earlier. So it really was a change and a shift, which was really a great period to really be getting involved in this area. It hasn't stopped being fascinating, as I'm sure you hear as we carry on. So let me stop there.
Thanks, Bon. And maybe as a follow-on to that, so, I mean, obviously you had the international visitors who helped with the capacity building, but the truth is that our act is structured very differently. You know, the public interest test that Michael has alluded to, and we're certainly going to spend a lot more time on that as we progress, but you didn't have precedent on that to look to internationally. Maybe tell us a little bit how you navigated that in the early days when you couldn't rely on, you know, sort of the international learnings, and how you think that develops and what stands out to you for that period.
I mean, I think the history of why our Competition Act is structured the way it is has been traversed already. Michael spoke about the JSE at the time and what it looked like and the concentration levels. And the intention really with the Act was to break those concentration levels. But there was also an appreciation that dealing with concentration levels purely on an efficiency basis wasn't going to be sufficient to address the legacy of apartheid that South Africa inherited. We know that when you have a horizontal merger, there's likely to be duplications and there's likely to be job losses, and therefore in developed economies that's just how it goes, because those jobs will be absorbed somewhere else in the market. But with a history like South Africa, where there were high levels of unemployment, levels of people not really educated to be able to be absorbed in other areas, it was really important to make sure that there are also equity and distribution goals that are covered in our Act. And we had a very active trade union movement, primarily because of our history, and in fact that's what also contributed to the change in '94. And so from the net processes and having really an inclusive economy, I mean today, inclusive economies are the catchphrase throughout the world. Even our counterparts who commend us now from the US and everywhere else about how we balance the public interest issues and competition issues is something that is being followed in other jurisdictions. And so when we talk about creating an inclusive economy as a buzzword now, it existed even way back then. How we actually implemented it was because of the institutions that were there. These issues of whether it's employment or whatever public interest issue was relevant would be debated in a public hearing at the tribunal, if it's a matter that goes to the tribunal, and there would be transparency about what the impact on employment would be. I know that in the corporate space that was really not something that was expected because you don't have that balance. But the real value of the institutions and having to appear before a court and hear the evidence that is being led about what the impact on jobs is going to be, and really also encouraging business to look deeper, because one of the things that happens is that we find the focus is more on the efficiency side of the merger, whereas in real terms there are jobs that are going to be affected, and therefore the fact that employment conditions, for instance, had to be looked into forced a little bit of an engagement to looking at the public interest issues, knowing that they're going to have to be justified before an independent tribunal, which can also be appealed to the Competition Appeal Court. And Dennis is here, and you know the Walmart decision is just one such example where the public interest issues were debated all the way to the Competition Appeal Court, where there was not a competition issue at all. And so the balance, to answer your question, was through these institutions that really engaged with the issues, and the public knew what to expect. And I think that has been one of the most laudable things. Our counterparts, when we go to the IC and the International Competition Network, which is a forum, a platform of for being at the forefront of engaging with public interest issues, because today's public interest issues are sustainability issues, which we hear the European Commission talking about today. They're not traditional competition issues, but they are being addressed through competition policy and regulation, because the world is a dynamic place. It's not static, and we cannot expect that traditional application of competition tools is going to make the change that is required for sustainability.
Yeah, we certainly are seeing that with our counterparts abroad starting to grapple with these issues and asking us for our views on how the sort of public interest stuff fits into merger analysis. I wanted to make one other comment, and that is, oh yes, you wouldn't believe it, but 25 years later, I am currently grappling with the threshold question, which is the first time in a long time, but I thought I wouldn't still be, but yet here we are. Judge Davis, if I can move on to you. The design of the Competition Act had very specific objectives in mind. With the benefit of hindsight, do you think the architecture of the Act has been conducive or optimal in achieving these objectives? Do you think the Competition Act's been successful in achieving at least some of these objectives? I mean, what is your thoughts on how the Act is structured and whether or not it did what it said on the box? So I'm not sure.
The King's Cross Harbour in London, because the group that met were headed by Alistair Raiters, who was then the Director General. It was myself, David Lewis, Norman Manoyan, and the remarkable Eleanor Fox, and one other person who I can't remember was a Canadian economist, but didn't contribute quite the same amount. And Michael's right, of course, the concentration issue was paramount. But remember one other thing, and you'll find this in David Lewis's excellent book, Thieves at the Dinner Table, that what had actually happened was that Mandela had gone off to Davos in, when was it, 91, or the case was. And he was asked, what is the ANC's economic policy? I always start my competition lectures by asking my students, what do you think Mandela answered? To my shock, I can tell you almost consistently they never have an answer to that, which just goes to the level of social amnesia which we have in South Africa. But the answer, of course, was that he said, in terms of the Freedom Charter, it's nationalisation of the key industries. At which point, all of the entrepreneurs at Davos spluttered on their Langevulin and other whiskies and said, that's not a good idea. You won't get foreign investment as a result. And it was partly because of that, that when he came back and said we have to rethink things, that the how you deal with questions of concentration, and particularly concentration in White House, that the Competition Act was effectively born. It was those two factors. And Lewis documents that pretty well in Thieves at Dinner Table. Now the difference then, and I think this is terribly important, the difference then was thanks to Reuters and the people around that room, I think we had a reasonably good idea what competition policy is. I should tell you, I don't know what competition policy is today. I have not the slightest idea what the competition policy of the government or is at the state which informs anything. And I say that because at the time, the idea was to have an act which would respond to precisely those questions of concentration, the problem about the redress around the Freedom Charter, and how do you marry, as it were, traditional cognizable competition questions, as Michael's indicated, of basically efficiency, meaning output increase and, output diminution and price increases, with the broader public interest questions. And that, if you look at the preamble in section 2, leave aside the public interest, that was the deal. And so I think at the time, it was a fairly carefully calibrated act, which I think has been hijacked recently by all sorts of mad ideological positions, which I'm more than happy to explicate upon under questions. So I think the act was a sensible balance between the two factors. The challenge, which I think to some extent we failed right from the beginning, is you'll search long and hard in all of the jurisprudence for an attempt to amalgamate traditional competition questions with the broader issues which you could broadly call public interest, but not just for mergers. I have to say that the only case in my entire career, and one of the counsels in the room today, so I'm not going to embarrass him, but it was one of the only cases in the Walmart case where there was an attempt to try to engage with what is the appropriate normative framework of competition in South Africa, which unfortunately we have not done. So in fact, the vast majority of cases have an incoherence attached to it. At the time, I think we had a reasonable idea, but we never met those challenges to the extent that we should. So, but I think inevitably, the idea that competition law, to quote Norman Manoyan in the Walmart tribunal case, wasn't to change the world, but to deal with those particular confines within the parameters of competition law was needed. What are the problems, which is I think what you're saying, what do we do wrong? I'm not sure we did anything wrong at the time. As I say, I think that those discussions at the King's Cross were utterly remarkable over 3 or 4 days. I think we couldn't predict certain things. One, we couldn't predict the effect of globalization in 1997, 1998. GAFA was not a predominant feature of the world economies in 1998 extent they are now. Lurking around at 1998 wasn't that awful South African export, Elon Musk, right? But that's first. So the nature of the economy and the nature of global value chains only came slightly later. And in fact, I only really learned about global value chains really full when I was involved in the Walmart case, because it was central to that case. And it was only because I happened to climb a mountain with a man called Michael Morris, Professor Michael Morris, who's one of the world experts in this, that I suddenly started to get lectures about what that meant. We didn't know that in 98. We didn't have the same level of attention to inequality that you have today. It's remarkable to me that if you look at the year 2024, there are all sorts of books now being written by serious economists like Joseph Stiglitz, Martin Wolf, who are complaining about the fact that the traditional competition was inappropriate. What was supposed to take place? So we didn't have that as a benefit. Mention has been made of David Lewis, and I think it's important to also mention this. In 1998, when the Act came into force, people of great talent were prepared to step forward and go into various institutions in South Africa, whatever they were. You only have to look at the nature of the Constitutional Court. Some of the other courts, you look at the competition tribunal at Lewison and Noyam to start with, I mean, remarkable. I mean, the problem that Mongo has at the moment is, quite frankly, it's much more difficult to get that sort of person into the system than it was the case then. Much luckier. The same is true of the Competition Appeal Court. I did not know when we started that I would lose so many talented people so quickly. I mean, just to give you a sense, over time, I lost Owen Rogers to the Constitutional Court. I lost Tabani Jolly to Commerce. I lost Judges Dambuza, Wallace, and Bakwana to the Supreme Court of Appeal. No country of our size can afford to lose that level of talent from this particular court and then think that you're going to have the same standard. So those were issues, Jocelyn, which we couldn't predict at the time. And one of the great failures of South Africa is that we developed Rolls-Royce legislation without thinking through what the institutional capacity is to implement those. So to be perfectly frank with you, I don't think we could have foreseen that. Do I think the Act should be different in 1998? For reasons that Michael's articulated, and I've just added to, the answer was no. Did we get it reasonably correct? Yes, we did. Have we been helped to carve out a framework which says there are certain areas that competition law should not enter? No, I think we did well at the time. But please remember one other thing. What has happened subsequently, which we also couldn't predict, is the failure of other institutions. So, for example, if you take black economic empowerment, frankly, it's not the job of the Competition Commission to deal with that, or the court, or the tribunal. That should be the Black Economic Commissioner, and those institutions have failed. So now what you've got is this absurd situation where the competition authorities are expected to do things which ultimately should be in the province of other institutions, and therefore create sort of problems, which creates, I think, a somewhat higgledy-piggledy jurisprudence. None of that could have been predicted at the time.
Thanks, Judge Davis. I mean, I'd like to touch on many of those things, and I think they do come up in our subsequent questions. So maybe tomorrow we might jump ahead a little bit to answer, to touch on some of that Judge has raised. But maybe let's just sort of start a little bit with your sort of 25 years, what you think, your experience. You joined the Commission in 2008, you've had also a long journey. 2006, sorry, forgive me. Maybe if you could just touch on what you think the biggest achievements are, and then maybe we can dovetail straight from that, and I'll sort of put a specific question to you about some of these issues that the Judge has raised.
Yeah, sure. Thank you for having me. It's good to start, I think, on a point of reflection. We are so busy, the 300 mergers every day, that it was actually quite a joyous moment for me to go back to 2000 to read the annual reports and to see how far we've come.
And I think to start off with, I thought about three main things as big achievements. And the first one was that the Commission has always been a kind of engine in finding information about how markets work. And from the beginning, it was not just an economic regulator, but there was a sense of putting information together, doing concentration reports from the 2000s, you see that it was done in the very early years, and really just being a repository of that information and that level of understanding across a wide range of markets. And when I moved, someone once accused me of being in an abusive relationship with the Commission, because I've been there, left, came back, left, and came back again. But when I was in consulting, one of the first things we would do when we entered into a new project was to say, was there a tribunal decision? You can't work in petrochemicals without reading Cecil Engine, for example. It was just such a rich place for information. So the one is the knowledge of how markets work. The two, I think, the second one that came to my mind immediately was the openness and accessibility of the hearings, particularly at the tribunal. And one that really sticks with me is actually a recent one, the Heineken matter, Heineken Distel, where there were representations made by seasonal workers, and particularly women. And it was a kind of shall I say, competition adjacent issue, because it really was about the struggles of these women and seasonal workers in that space. But Mondo at the time dealt with it so graciously and with such empathy. And it was really, for me, kind of democracy in action, almost like a people's tribunal. Yes, you don't come there with a competition issue, but it was something that was relevant to workers in that company. And to the company's credit, I think they took up the challenge and then, committed to kind of conditions that dealt with it. But the openness and accessibility, I think, is important and will become even more so when we come to the issues of independence, political influence, and also economic power from concentration, etc. We'll get back to them. And then the third thing, I think, was also around building a professional class. So those of us who have come up through the ranks, I started as a junior analyst in enforcement, and now divisional manager at at mergers. There are people like Trudy, Pam, who've gone on to hold important positions, I think, in the economy. And all of that has come from the kind of critical thinking that is forced upon you when you're in that space. I was telling Yazal earlier that I remembered a case I did in 2007, I think, just after I joined. We were investigating exclusive leases in supermarkets, and a gentleman briefed Jeremy Gauntlet. And there we walked in, it was myself, Mapato, and Sipo, and we were all kind of slim little people. And I think he was kind of alarmed and shocked at having to face these kind of young people. But we were trusted and given the responsibility, and you could run with the case from beginning to end. And really, to the credit of the commissioners, I think they really believed in us and gave us the power to develop. But I know I've probably got only a few seconds left, but I do want to go through the different epochs. So going through the annual reports from the 2000s up until about 2005, what was interesting to me was that this issue of promotion of a greater spirit of ownership was actually top of mind. Those reports talk a lot about how many BE transactions were notified. There was one case where parties were actually instructed to change the ownership structure to ensure that their BE partner had control because there were competition issues. But when this was done, it would mean that this company would count as a new entrant into the market. But at the time, I think Black economic empowerment was more generally accepted politically, economically, as kind of the way to effect transformation. And that was kind of very, very present in the work of the Commission in mergers. I think now we ask questions about whether or not it legitimizes concentrated structures and whether or not that's really the way to a dynamic economy. But that was interesting. The other thing I think that we mustn't forget is that just because we didn't get decisions on some abuse cases doesn't mean we didn't have effect in those early years. So the Hazel Tau case is a good example. I mean, that was an incredible decision, 2003, 2004, that not only had impact in South Africa, literally saving lives and reducing the cost. I think we did an impact assessment. There was about a 4.4 to 6 billion saving to the fiscus in 2016 rands, but literally saving lives. And that was done, by a commission who was still kind of struggling to find its feet. Then in the kind of 2006 to 2010 period, there was a responsiveness to the plight of ordinary South Africans. So very much a focus on prioritizing which sectors, the bread and butter issues, the cartels in bread, milk, milling, etc. But also, I think, a very active merger regime. So the Cecil Engine merger again was very much about understanding not only competition at the time, but also how the market would change with deregulation and how that would impact incentives. And that kind of foresight to look at the changing nature of markets at the time was, I think, a huge achievement for a young authority. And to wrap up really with the most recent, the agility that the Commission showed during the COVID-19 pandemic, the fact that we prosecuted those price gouging complaints at a time when other authorities internationally were kind of thinking about it, and we had actually done it, is something that we really should be lauded for. I think we can have a conversation about the quality of the evidence in the case, but I think just that agility, and the thing that we shouldn't forget is that this was also a period where we did see greater interest both from politicians, well, specifically I should say from politicians in the work of the Commission, and the kind of political acumen that was required to kind of protect the space, I think, is probably something that we need to appreciate. So that the contested space, I think there was a lot of protection of the independence of the authorities by the leadership at the time. And then lastly, the issue around the soft power, so the issuing of guidelines, the use of advocacy in kind of automotive markets and school uniform cases, etc. That was quite I think a big area of our work that was developed during the last period. So I'll leave it at that.
Thank you. I suspect we may have a question from the audience a little later on the COVID cases.
Yes, sure.
We're around the room, but let's leave that for afterwards. But maybe just to come back to the point Dennis was making, in that, in this public interest space, the Commission has, in a sense, been a victim of its own success, right? And so where other policies, other institutions may have failed, all of these things have now become the responsibility of the Commission. So we're now seeing some public interest issues in the BE space find its way into the remit of the competition authorities. So there's quite a lot of pressure, I think, being brought to bear on the Competition Commission within the sort of where it sits within the DTIC to cure all of the ills that don't normally fall within what we would say is traditional competition, right? So how does the Commission deal with these challenges? And maybe if I can add to that question, your view on sort of where this is all going and how sustainable it all is.
Yeah, I mean, that is a loaded question. We often get asked this question, are you a victim of your own success? Are you doing more than what is required? And actually, in thinking about it, I was wondering kind of where does this come from? Are we talking about things like the health inquiry, for example, that should be in the remit of Department of Health? Are we talking about the data inquiry that should be in the remit of ICASA? But actually, I think that those are areas where the Commission should be involved and has made a difference, and probably the question is why. And I actually have a similar response to what Judge Davis said. The structure of the competition authorities, the independence of the Commission, and also the kind of the single issue focus and the market experience does make us a little bit more effective at resolving those concerns. So we did do in telecoms what ICASA has failed to do by getting some kind of agreement on a reduction of data prices. We are looking at the way in which these markets will develop and in merger control. I think have taken a stance around what dynamism in those markets require, more so probably than the regulator. In keeping with your Dumbledore, I won't mention the name of the case. We'll call it the Voldemort case. Case that shall not be named. But So I think we probably haven't tread in places where we shouldn't. I think the bigger problem is, should we be the primary authority? And that's probably, the answer there is probably no. The one that's most top of mind, and I think the one that causes most concern, is probably this issue around transformation. Should more be done? Absolutely. Should the BEE Commission be more active? Absolutely, I think they would agree. But I think in my older age, I've also become a little bit more open to kind of the benefits of incrementalism. So should the Commission do nothing? No. I think transformation of markets, opening markets to new entry, building a black industrial class, all of those are important to competitiveness of markets. And perhaps better is good. So taking these small steps, yes, they should be taken by the Commission, but they're definitely not going to cure the bigger problems.
Maybe if I can then just jump in. I know I might need to curtail some of these questions, but maybe just to, given the incremental nature of these things, there's sort of emerging parties who do a number of deals. I think there is a broad concern, and no doubt it will come from the audience, that there is a sustainability issue where parties are repeatedly asked for commitments, in a cumulative way. And maybe just the Commission's, or at least your view, on really where does this all go? And so we have a residual sort of sustainability concern of what this may do to sort of foreign investment into the country. I'm asking the controversial question. I think Judge Davis probably wants to weigh in here as well, but maybe tomorrow you and then I'm coming to you.
Sure.
Yeah, our approach to this, and I think we are talking about the promotion of the greater spread of ownership, right? So let's just put that out there. Our approach to this is evolving. I think initially we were a lot more kind of aggressive about requesting commitments in each transaction. But you will see that of late, what we do is kind of take a step back and say, who are we dealing with here? Have these firms committed to conditions previously? What is their general kind of response to the public interest test more broadly, beyond just the promotion of the greater spread of ownership? What do they do in terms of developing small businesses, HPs, etc.? And we take all of that into account when assessing whether or not further commitments are required. Practically, there have been benefits. So I can give you the numbers. So in worker equity between 2019 and 2024, there have been 60 billion worth of transactions. In CapEx, about 69 billion. Not all of that being a change in CapEx. Some of it is maintaining free spend, etc. 238,000 workers part of ESOPs. So there have been benefits. But I hear you on the sustainability. The thing that isn't sustainable, though, it's a highly concentrated economy where Black South Africans are still not participating equitably. Barriers to entry are high. Small firms are not growing, as our concentration report says. Small firms are not growing to medium firms. They're not growing from medium to large. We have high levels of unemployment, official unemployment, and that's not sustainable. So we do need to think about how we address those bigger issues. And though public interest may be a drop in the ocean, I think it's definitely a drop that counts in the context of the scale of those problems. So I'm going to deviate from our listening to give the Judge Davis an opportunity.
Can I just sort of say, competition law, on any basis, is to make markets work. It's not to change the world. It's not to replace the entire economic policy. Make markets work. Now, in the South African context, what that means is to make markets work inclusively. And 60 million people have a fair crack at the participation in this economy, which tragically our history prevented, and still does. I accept that. There's no replacement for the fact that we have no economic policy of any coherence in this country. Every budget is nothing more than a bookkeeping exercise. Quite frankly, we have no clue as to we're going to grow more than the predictions are we're not going to do more than 1.5% over the next 3 years. How do I know that? Because that's what Treasury told me, and the Reserve Bank. So do we need an economic policy which addresses the points of tomorrow? Absolutely, I have no difficulty. Can competition law do that? The answer is absolutely resoundingly no. That's not its job. Its job is to make markets work inclusively, which is why I come back to the point, what is our competition policy? You have to have a competition policy that guides the law. We have no policy that guides the law. I can't find it, and it's not there. I assure you. So then, if you then look at the public interest question, tomorrow knows this because I've addressed the Commission on this and I've spoken about this. I think that there is such an extraordinarily convoluted set of guidelines that make anybody boggle. Because the question is, you do not transform an economy by, ESOPs. They're probably the worst and most stupid thing to do, because what happens is if workers get a few shares, which they then sell as quickly as they can, because it doesn't empower them, and it doesn't change the trajectory of the company which they're part. It's absolutely nonsense. Neither is rent seeking the object of competition, which is say, well, if you give us 2% more, we'll leave the merger. The question really arises as to what those public interest issues should be for, and they are to promote an inclusive economy. And therefore, instead of fiddling around with things that actually are nothing more than a bargaining exercise rather than in the sense of transformative exercise, we should really revisit how we deal with this. Because the fundamental problem, in the first place, is there shouldn't be a disjuncture between the public interest questions and what you call traditional competition jurisprudence. Mention has been made earlier, and quite rightly so, that competition jurisprudence in South Africa can't just rely on Chicago or even post-Chicago economics. It's not part of it. It needs to harmonize between these various competing so that you get some level of coherence. And then you get, as it were, a promotion of competition law which promotes a coherent competition policy. It's highly unfair for the Commission to be expected to do all the heavy lifting which transforms the economy, and it can't do it. And what's happening is, in fact, complete incoherence. Let me give you one example. I am totally in favour of small and medium-sized businesses, particularly those which should be owned by black South Africans who have been utterly and outrageously discriminated throughout the vicissitudes of South African history. But there's a place for large firms in a global economy. The question of development doesn't just only mean small firms. The question is how, in a country like South Africa, do we get this mix right? That requires really thought as to how you have a competition policy which informs the law and gets that balance correct. The notion that ideologically, if you're big, you're bad, is insane, because that's not true right across the board, and it loses jobs, it loses capital, and it loses, in a sense, the opportunity to grow. So what I'm making a plea for is effectively we need to think through what is an appropriate competition policy in the 21st century. And then one final point. I can't help but say this. I don't think that the authorities, whether it's the tribunal or the court, are helped by and large by the cases that are argued before us. Because, and I've told you this before, and you know my point, because attorneys persist in briefing people who think that today can be a running down case and tomorrow can be a competition case. We really need to have people before us who understand the nuances of competition. The tribunal is under-resourced. Mondo obviously agrees with that. It has a huge workload. It requires assistance. Trust me, in the court, we desperately need that. Otherwise, we scratch around ourselves. And so we have to have, this is a competition policy that ultimately informs, but we also need to have a jurisprudence that informs that, and that means having people appear in front of us who ultimately have an understanding of competition law and how it should apply indigenously. Now, there's some glorious exceptions to my general view, but But I'm afraid to say, in the vast majority of cases, in 25 years of doing competition law, I can probably count on my two hands where I've really been truly assisted. And my colleagues feel the same way.
Challenge, I think, for the...
It's up to you people.
I am going to try and get back on track on our questions, but I wanted to just ask Tamar if you wanted to respond to any of that, or if you're happy for us to slightly change tack. But if you do want to maybe just answer some of that, I'm very happy for you to go ahead.
I don't know if this would be surprising, but I think I actually agree, and I think broadly the Commission would agree with this issue around space for large firms. In fact, I was thinking about where we're going to go, because I imagine you probably asked me what's next. And I think we do need to reckon with the fact that we haven't, the economy is not growing as it should.
Mm-hmm.
And the 1% growth that you talk about, that's kind of a base case from Treasury. If we remove structural constraints, for example.
Yeah.
So we have not achieved the growth. We've definitely not achieved the dynamism. And we have a discomfort with large firms that I think doesn't sit well with the way that you should approach optimal competition. So there I actually do agree. I do agree that we need a competition policy. I do agree that we need to think differently about how to make markets more dynamic and how to dovetail better with industrial policy and ensure that large firms are part of the kind of growth trajectory, but with specific reciprocal control mechanisms to ensure that they are efficient. I mean, this economy is not going to grow without a Cecil doing well, for example. You know, it's just too important. And that is the question that we need to grapple with. Also, the green questions, those are the sustainability questions are not going to be addressed without a reasonable application of the exemptions framework, because there is going to have to be some kind of coordination and cooperation amongst firms to address those issues. So that's going to be the new challenge, is kind of how do we use competition cooperatively in achieving competitiveness internationally. Yeah.
So I'm afraid to tell you that we're on question sort of 10:30. I'm going to just change tack slightly and jump ahead a little bit. So I thought I was going to try and keep us to time, but we've got half an hour left and we haven't done so well. Although this has been a great discussion. But Mike, maybe I can turn to you. Just, sort of on some of the commercial issues. You are one of South Africa's leading lawyers, the leading deal maker in the country. What would your advice be to parties wishing to engage in merger transactions as regards the merger process in South Africa? And how has the public interest test potentially deterred investment in your view?
Dennis correctly observed that the world's changed. And one of the most significant ways it's changed is that there are many more countries today trying to attract the investment dollar. And in attracting the investment dollar, you have to look at your international competitiveness. Dennis and I were on a tax commission. Dennis and I have been on company law. Apart from anything else, whatever you do in proposing laws, they must be internationally competitive. So it doesn't mean you don't take cognizance of the needs of the domestic economy, but it has to be internationally competitive. Now we're talking about growth. Unless we attract foreign direct investment, growth isn't even a question. So what we're really lacking in the whole debate on competition involvement in South Africa is the impact on foreign direct investment here. And I can tell you anecdotally, on a number of transactions I've been involved in currently, people say, we're going to bypass South Africa. We've got a timetable, you've got a transaction, Say an American company wants to take over a target, it's got subsidiaries all over, very tight timetable, but the South African dimension of it isn't going to work at all. So you have to look at the content of your law, that it's internationally competitive, and how it's implemented, the certainty of implementation. So I can tell you, to be absolutely graphic about this, when people talk to me about an investment in South Africa, they say, A, we don't know what the public interest test is going to result in this transaction. So this could go on and on forever. And the one thing you know as an M&A lawyer, speed is everything. So that's the first thing they say. We don't know where the debate's going to go, and we don't know how much it's going to cost. This deal can sustain so much. Anything more that's required takes it out. So it's interesting, already in 1989, when James Baker was Secretary of the Treasury in America, he said tax law going forward is going to be determined by three things. One, rates that are internationally competitive. So what we really have to do is, and Dennis has made it absolutely right, and I don't want to add anything there, but the balance between public interest and adverse to competition is really, with respect, getting out of kilter. And getting out of kilter with significant harm. There isn't regulatory certainty. And on anything, we just helped government with the new amendments to the Companies Act. And on every one, we said, how certain is this to comply with? Because when things are uncertain, it's administratively costly and compliance costly. So I do think we've got to get a much more coherent balance between adverse impact on competition and public interest. Dennis has made all the arguments very eloquently. I just wanted to add that international dimension.
Thanks, Michael. And maybe just to move on, Mondo, to you in this regard. A number of these issues are, in a way, untested. The Commission has been grappling with the interpretation of, and here we are, talking in particular of the new ownership criteria. The Commission has an interpretation that, what is required is a positive obligation to increase ownership. Michael's talked about, the impact that this has on timing, certainty being, the two most important aspects of M&A deals. Maybe just to hear from your perspective, whether you think this position is sustainable, but also, the tribunal's approach to this particular issue.
Yes, I think I should start by saying that we haven't had to decide a case that has required us to test this question of whether there's a positive obligation as per the Commission's guidelines. And so I will tread carefully because we have to wait for a case to come before us. What I can say is that we have had these transactions come before us, and without the benefit of a full hearing and arguments being made for and against, it is now impossible to determine whether that's the correct approach or not. But we can't wait for that case to happen because it isn't being brought for that matter. So what we do as a practical approach is to assess each of the cases on a case-by-case basis. And what we've done in a case that is often cited, it's the Epiroc decision, where there was going to be a dilution in HDP ownership post-merger from about 98% to 28%. And the question was, is there then an obligation to do something with that dilution? And again, we didn't have full benefit of argument around the issue, but the Commission and the major parties agreed to a 28% HDP shareholding, which also included 5% ESOP ownership. So the reduction was from 98 to 28, 5% being an ESOP owned entity and the balance being an HDP owner. How we decided it was essentially also to look at the other public interest benefits that would arise from the transaction. The acquirer was an international firm, and they had R&D and had started acquiring other businesses in South Africa. What they were saying in terms of the efficiencies and the promotion of exports in South Africa was that they would be able to actually turn around the local business that was in mining and producing some products that are used in the mining space. And they would be able to export those products to international markets. And they actually showed us evidence of an acquisition they had done some 2 years before, where they actually promoted exports. So in that context, we took into account other public interest benefits. And what didn't happen in this case is that the parties didn't bring them forward necessarily before us, because the focus was on the greater spread of ownership. And when that was tested as to the dilution it was bringing, and then the other issues came up to say, actually, there are also these other public interest benefits. So I think one of the perhaps lessons to be learned from that is that as parties also file, we should be looking comprehensively at all of the public interest issues, because what we've taken as an approach is to look at the public interest issues holistically and not focus specifically on the greater spread of ownership. In that decision, we do say that we haven't had the benefit of a hearing, and therefore we don't know what the outcome will be had we had a hearing. But secondly, we also say we've taken this holistic approach to public interest issues based on our historical approach, which was pre the amendments in 2018, and therefore we taking the same approach, but minding the fact that it was pre the amendments, and therefore we don't know if the matter was to be ventilated fully, how that would come. But I think it is a sensible approach. I'm hearing Tamara also saying that the Commission is taking that more holistic approach on a case-by-case basis. I think the jurisprudence in this area is evolving. And in the same way that we ultimately ended up with the Walmart decision in the case, I want to come just back to that about competition policy and whether it encourages investments and international competitiveness. Walmart is an example of that case because, like I indicated earlier, there was no competition issue arising out of the Walmart decision. The issue was just an employment issue that then raised the question about whether the public interest issues had been adequately considered and whether the competition effects outweighed the negative impact on employment. One of the things that the Competition Appeal Court did in that assessment was to recognize the globalized nature of the business of Walmart, and then brought it home to say, what is the public interest impact of that transaction here? The evidence that was led before the tribunal that the Competition Appeal Court also looked at was the fact that Walmart is an international business. There were potential issues of imports coming into the country, therefore impacting small businesses that were part of the supply chain into Massmart at the time. Those considerations were taken into account holistically, and some of the conditions that emanated from them was to protect the public interest issues that would arise from perhaps imports coming into the country. So local supply chains and procurement conditions were put in place. And so for me, I don't see that as a move completely from applying competition law in a way that balances the public interest in a rational way that the two are connected. What we are seeing now with the recent amendments and the case-by-case approach I'm talking about, it seems to me that exactly that is happening in the sense that when the public interest issues are brought before us, they tend to be about localization, to say, okay, is there going to be an improvement in localization in cases where there is a negative impact on public interest issues? And so the case-by-case approach is really what seems to be the answer to that. It may seem as if it's not coherent or that it's moving away from really the core of traditional competition law, but actually on a case-by-case basis, I can tell you when we hear these cases, we ask the questions about what is it that this public interest element is trying to cure. And you'll be told that there are local supply chains here, there are trucks that move from here to there are small businesses that are going to be cut out, and therefore you make sure that the public interest element that you are imposing, because ultimately we have to create the certainty which isn't the same for every case. Parties have come before us and said, we are not able to implement an ESOP in this transaction and motivate why they can't, and then tell us what they can do instead, and depending on whether it addresses a public interest, then the conditions are then imposed. So I do think that to not engage with these issues is what is not sustainable. We also obviously want to encourage foreign direct investment. One of the interesting things that I find on that topic is that when we go to international forums, whether it's the OECD or the ICN, South African competition laws are applauded, and people say there is transparency about what we can expect. Perhaps the issue is in the interpretation of how the public interest issues would be applied, so that I can understand that it's not completely watertight, it's a case by case, so it does create uncertainty. But we hear a lot from our counterparts that there are public interest issues in other jurisdictions that are not even in the Act, that people don't know what they might expect. The minister of whatever ministry in another country could come in and require that there be some public interest issues which are not defined. And so we have the benefit of that. We also have the benefit of all these other systems in the higher courts where the commission, the tribunal, and the appeal court can really engage in these things. So I think I'll make this statement, which is that we have to do our own bidding, because what I find as competition practitioners, whether the tribunal or practitioners in practice, I think in the way that, and I was in private practice for a good 7 years before I went back to the tribunal, what we advise clients is very key, and our approach to how we say what the public interest issues is will obviously impact how foreign investors also take a look at how they decide. And so if we don't have confidence ourselves and believe in what the Act is trying to do, which we know is trying to address historical imbalances, and it also is trying to say we want to attract that foreign direct investment, and it's saying we are not saying no to concentration. The amendments in the 2018 explanatory memorandum acknowledges that concentration and big is good, because national industries must also be able to compete, and that provision is still there. So to me, there's nothing in the Act that says the objectives that are sought to be achieved are way out of kilter. The issue is the application. And on the application, I think, to the extent that we have authorities that are independent and things can be tested, it gives some kind of comfort. And so our own bidding to the investors and so on that we engage with should be about this piece of legislation that anywhere else in the world people lauded for its transparency, for achieving things that most of the jurisdictions are trying to follow now. So we need to also just not have a blind spot on those elements in terms of how we then engage with different stakeholders as almost like the people who are at the forefront in terms of bringing these matters before the competition authority.
Thanks, Mona. I have a number of things that I'd like to actually just come back to on that, just, regarding this question of interpretation, because I think, drawing together what Michael has said, what Tamara has said, and what you have said, it's about certainty. And I think the world we find ourselves in is this open interpretation question, which is, sort of impacting on that certainty. And I think that we are all very keen to get some clear certainty on that, because I think, and certainly we see it too. We have a large number of foreign counterparts that we deal with regularly on broad global transactions, and they are all saying that what we call public interest forever are now broader considerations that they are grappling with themselves. And I think we don't see resistance to the concept of making good, right, of curing harm. I think if people know what is required, if people have clear guardrails, we don't see any resistance to that. I think the difficulty is in a world where there is some positive obligation. How do you know how much is enough? How do you cure something that, to our minds, where there's no harm? I think that is really the interpretive, I suppose, space between us, which I know is obviously the point yet to be decided. I'd like to maybe just move on to a forward look with the last 10 minutes, but I do want to give any last opportunities on this public interest question. And Judge Lexman, am I reading your body language? You wanted to make a comment?
No, I'll just say this. I don't think, I understand a case-by-case basis. Obviously, every case has its own facts. But you've got to have a certain jurisprudence. Michael or you, for example, when you advise clients, need actually to say this isn't a roulette wheel. There are broad principles in terms of which you can advise clients. And I should say, I understand this point about South Africa being heralded, but since I've retired, I've had quite a number of discussions with large corporations who asked me for advice, and their concern is the one that Michael articulated. They're not sure. Now, what does that mean? That means not that cases will go differently, because we all know that cases are fact-intensive, but there are fundamental principles. So if you take, for example, Walmart's not necessarily, there's this idea that there's this disjunction between competition and public interest in Walmart. That's not correct with respect. Why? Walmart was about making markets work properly. It was to ensure that small and medium-sized South African businesses would be able to operate within the context of a multinational corporation. That's a competition question, for goodness sake. And that's what we were trying to do in Walmart. What we were trying to do in Walmart was to have something which we could say to you and Michael, now go and advise your multinational clients, understand there's certain obligations, understand the obligations to make markets work in South Africa, given our history. You want to come into the country, this is the deal. But Michael, you would then say to the client, it's going to cost you X more, you'll work out whether you're going to get a return or not, and everything's fine. You won't suddenly go through all sorts of litigation and say, wow, but that wasn't what you told us, which of course in the general view is, of course, the judge's fault, I understand that. But what I am trying to say is that that's absolutely critical. Now, Epilogue, strangely enough, is the one case that I teach with favour of recent jurisprudence in trouble, because I think it actually is a start. It's not a particularly coherent judgment, but it basically gets to some holistic view. That's what we should be angling at. I just want to make one final point, is I'm finding this discussion between, if you could call it traditional competition, which I understand is output price, right, and the rest, actually somewhat disconcerting. Because if you look at the modern literature about competition all around the world, people are looking at the issue of competition, not from public interest alone. There's a great article by Salop and Baker about how you actually, through abuse, etc., how do you actually deal with inequality? Not for public interest, but through the concepts of competition law itself. That's where we need to go to. If people say, that's how you interpret it, you guys can give advice that is proper. And frankly, let me make this point absolutely clear. We should have learned from the three Nobel Prize winners, Acemoglu, Robinson, and all. Why do countries actually grow? Because their institutions work. And what does that mean? That you've got open and transparent, accountable institutions that people know how they're going to work. You can't work behind sort of voodoo economics or what have you. You have to be able to have those institutions. And I'm very disturbed, not just about, frankly, nothing to do with competition authorities alone. I'm disturbed in South Africa we don't have a debate about that. You know, I mean, we can talk about the NPA, we can talk about all these other institutions, which ultimately are absolutely central that people understand the legal architecture in which we operate. And within this particular context in competition law, I'm afraid to say, well, I think everyone is a start. We need a hell of a lot more certainty in order to convince people. And I'll just make this final point. I'm always stunned every time I get invited by my doctorate student, Willard at Wembley, just how good COMESA are. They seem to understand precisely the point that there's no such thing as a country's exceptions. So no one is queuing up to help South Africa anymore. Hello, that was 1994. So we've got to do exactly as Michael suggested, we've just got to be better. And I'm fascinated the way COMESA is understood. They understand the reality of what is required if people are going to invest. And what they're trying to do is to develop a coherent jurisprudence for that effect. That's the challenge.
I am going to, with our last few minutes, ask both Mondo and Tamara in turn, just for their sort of outlook. What does the next 5 years look like? And then I will reserve a few minutes for questions. So maybe Mondo, do you want to go first?
Yeah, I mean, I think in this era that we live in, the only certainty is uncertainty. Unfortunately, our job as the tribunal is to provide as much certainty as possible within a realm of uncertainties throughout. I mean, not just in the competition space. We know there are new issues in the digital space. We've been talking about sustainability issues in the environment. All of these things are bringing challenges that are unforeseen, that require certainty in terms of how we deal with them. So I say this because I'm saying, first of all, there are new issues and they are uncertain in themselves as to how they should be dealt with. But we do have the framework of the Act that enables us to basically go through tick by tick, line by line as to what the issues are that we should be addressing. I do think that jurisprudence by its nature doesn't happen overnight. We can't fast track an outcome that leads to a decision. All of the small little cumulative things ultimately lead to the certainty that we all aspire to. And certainly it's a case of dealing with things as they come to a point where we will then have the certainty. I know that from a decision point of view, if you wanted to make an investment, you want to know what am I getting when and all of that. I can say this in terms of mergers in particular, because that's the lifeblood of an economy, that in all of the cases that have come before us, we have decided them within the time frames that are required. We are required to hear matters within 20 business days and so on. 87% of our cases and reasons for those decisions have been done within the periods that are determined in terms of the Act. For matters that are contested, which generally mean that you are going to have long protracted hearings because there are interveners that want to come before the tribunal to make their submissions, and the parties themselves want to bring witnesses and expert witnesses. Those cases tend to run for longer because they are contested. But what I can tell you is that 100% of those cases, the pre-hearing, which is the first step of how we progress the matter, was done in the 10 business days. When the matter will then be heard later on, is a case of the availability of the parties, how many parties want to intervene, how many expert witnesses are going to be coming in, and all of that is really dependent on factors outside of the tribunal. So speed and all of the things that are being raised as things that the business community would like to know. I think on the merger side, certainly all of the cases that we have done speak to our meeting the timelines, if it gives any certainty to business. What that means, though, in achieving those targets in the way that we have, means that certain things are being compromised, like the prohibited practice side of the cases, your cartels and abuse of dominance, haven't moved as fast as they should for different reasons. One is that we also had the 2-year period of COVID where we put matters on hold because they are longer running cases. There are cases where you want to have them physically because you want to have the witness in the witness box. They're not like mergers where you can hear them online. Here you want to have the witness in the witness box and determine whether the evidence they're giving you can rely on or not. And those are matters that run for over 3 weeks, and you need to then have 3 weeks in the calendar when you are sitting and having that case. And there are several of those cases. They are coming back on stream, so in terms of the next 2 years, we see that some of that backlog is going to be cleared by hearing these cases. But, and Judge Davis has mentioned, one of the challenges at the moment is having enough people to run these cases. We've done a few experiments by getting acting part-time members. Those helped tremendously because we always look for solutions. When there's a problem, we find a solution. We did the acting part-time member positions, and these are people in the private sector who are not able to give up their practices forever because our challenge, we didn't talk about the challenges of running the tribunal. One of them is precisely that we don't have people who are willing to do this for what the pay is. At the lower levels, we're able to attract young graduates. They stay with us 3-4 years. After that, the private sector nabs them and they never come back. It's even more pronounced at a senior level where you need really expertise and years of experience. People are settled and they're not going to come and do this for what the tribunal pay is. It's national service. And so what you find then is that we've tried with the acting part-time member positions, and those help to boost capacity for that limited period. But for a sustainable tribunal, we do need to have more people on deck. I think the people in the room, because you are in the field, will be aware that positions have been advertised for full-time member positions. And so we anticipate that there will be appointments soon. And even with that, we know that it takes time to acclimatize. I mean, even the acting part-time judges that came to join us in terms of shifting from being a regulator to being a party that's appearing before the tribunal is also a different skill set and so on. But we anticipate that we will have full capacity and we'll be able to deal with all of these challenges and be able to process things much quicker and have the certainty that I'm sure we all aspire for.
Thanks, Mondo. That's encouraging to hear, I'm sure, for many of us in the room. You're right. There are a number of topics that we didn't get to touch on, but I'm glad that you mentioned that. Tamara, from you, could you perhaps share the Commission's vision for the next 5 years or so, and how business can prepare themselves for compliance with the Competition Act in the next period?
Yeah, I think, given that I'm on the floor, I'm going to take advantage of it. I just wanted to make a few points around the independence point, and also then around the transformation point. So on independence, I think the question that we're often faced with is kind of about political interference, right? And influence, particularly from ministry, because of their circumscribed role in public interest. And one day, I think the legislation does provide some guardrails, so at least you know that there's only participation on certain areas. Secondly, I think the tribunal does hold us accountable. So as Monta said, when we go to the tribunal, there was a time when you would go with the framework agreement and then it would be incorporated into a condition. That time has passed. We are asked to justify each and every condition on the basis of what harm it's seeking to address. So that's how we are investigating at present in order to prepare for that question that will invariably come. But that's not the only threat or challenge to independence that we constantly need to be aware of. The Americans, I think, when you listen to the FTC, they often speak around concentration in economic power giving parties political power. So the other area that we need to be cognizant of is large firms do have political power. Unelected officials, they can go to various places, lobby, etc. So it is fundamental that we also guard against that in the work that we do. And that lobbying, I think, is becoming very apparent, and you see it when you read the press. So that's also important, and something that we will, of course, have to guard against. The second one I wanted to talk about is that just in general transformation and how the public interest sits with the competition. I think Dave Lewis makes this point in the conversation with you, where he says we mustn't forget that competition is in the public interest, and I totally agree, of course. But we mustn't forget that public interest is about competition. So the fact that we saw the amendments bringing in the elements of small and HDP firms into abuse provisions was precisely because the legislation prior to 2019, the substantiality requirement kind of didn't give enough credence to the fact that small firms are important competitive forces and do need to be accounted for. So in the same vein, transformation, maybe it's a cause and effect issue, but markets are failing. Markets are failing to incorporate all South Africans, particularly Black South Africans, into productive activity. We've been saying this for at least the past 25 years. So this is a competition problem that we need to address. The cartels that we saw in bread and money, those were kind of networks of people who were familiar. They met, as you will recall, in churches, etc., etc. So transformation disrupts those relationships, and that is something that is important to the competitive process. But then where to from here, the next 5 years? I think we will probably see a shift, and this is me speaking, so probably I don't attribute this to the commissioners, but I do think we'll see a shift in the kind of work that we do. Market inquiries are going to become a lot more important, I think, as a tool. They are bounded, so yes, the abuse cases take long, but the market inquiries, as you know, should be completed in 18 months. They are intensive, they give a lot of insight into how markets operate. I think that's something that's going to be used a lot more. We are going to be pushed to answer questions about impact, how we're dealing with cost of living, how we're contributing to growth. Interestingly, when we go to Parliament, the questions we are asked is which sector have you deconcentrated? You say you are the Competition Commission, and we do need to be able to answer those questions. I think it's totally fair for parliamentarians to ask us those questions. So we are going to have to be a little bit more smart about our prioritization, about the interventions, and ensure that we can show impact. Thanks.
I was making a note there. I am going to then see if everybody's willing just to take a couple of questions. I see Woody is.
Thank you for this very insightful discussion. My question is to Tamara, and that is basically just curiosity from my side. as to why the Commission did not take into account the case law on ownership for purposes of its guidelines, dealing specifically with ownership. Because there are one or two issues on which the tribunal did give particular guidance, for example, in relation to the holistic view of all the public interest factors. And the COPCOM, for some reason, did not cite any of that. In fact, it went in the opposite direction in relation to some issues. So that was just my question. What was the thought process behind that?
I actually need to push back a bit against that, because the guidelines do say that the assessment is holistic, that each public interest factor will be considered and a net assessment will be made. But I think what causes the discomfort is that we've said there's a positive obligation, so if it's 0, 0, 0 and everything else, there's a plus, which if it's not met, it becomes a negative public interest. So that's probably what you're referring to. But in terms of it being a holistic assessment per EPIRO, that is in the guidelines. In terms of us looking at each public interest element, it is in the guidelines.
It is a fallback position, if I understand it correctly. In other words, it is a fallback position. In other words, the first requirement is to provide some kind of a percentage per percentage restitution. But then on a case-by-case basis, the Commission may deviate from that, as far as I understand.
No, I suppose what I'm saying is, okay, so if in a filing we get a submission, and generally there's no effect on employment, there's no effect on international competitiveness, etc., etc., and then parties say to us that this transaction is 0 to 0, the first question will be why it doesn't promote. So that's why I'm saying, because it's a positive obligation, if the 0, 0, 0 on holistic assessment then becomes a negative on the 12A3E. And then sometimes parties will say it's not possible to promote ownership, establishment for whatever reason, but we are doing X, Y, Z on each of the other elements. So it's because of that plus where everything nets out to respond to it. Yeah. Not sure if that addresses your question. Yeah? Okay.
Any other questions? Martin.
Thanks very much. Very informative. I had the pleasure of spending time at the Commission for it's probably half of my career, and I've now spent the other half of my career in corporate. And I can make a few statements, maybe less questions and more statements. And the first one is, I think there's been a tremendous development on the side of corporates on sustainability, and Michael has been involved in most of these stuff. Where as a corporate, you are responsible for a lot of sustainability issues. And I use that broadly in the sense that, employment is huge. I mean, every quarter I report to a board on what is our BEE targets, where are we getting, are we supplying, supporting small businesses, what does our gender profile look like? So there's a lot of these stuff that corporates are obliged to do on the side, and I would just leave it with you guys to think about, because we're already doing it. You don't have to do more to force people and corporates to comply. The second point, which I've learned in the last 13 years in corporate, is you don't have to be too worried about the market. It will sort itself out. There is a lot of pressure on business to try and find profitability, but there's a lot of other factors that influence how businesses operate. And there's definitely, I've never in my time have found that there's the objective of trying to force competitors out or trying to extort money or find super profits from customers, etc. The other interesting development that I've seen as well is the fact that you do M&A activity to try and find synergies, find opportunities for growth. That's a circular effect. It does come back. When you are able to find synergies, you generate a an income in order to grow further, which obviously has got a circular effect on job creation and economic growth and so forth. So I do think the market does work, and I'm not saying you should. I'm not at all advocating that one shouldn't have regulation. Absolutely, and I do think there's a lot of excellent work that's been done. But I do think in some way, and I'm not suggesting at all you should abandon what you're doing. You're absolutely doing the right things. But in some way, I think you can place a little bit of trust in the market.
Anybody want to
Sorry?
respond? No.
I just want to say, sorry, but I don't think that's right at all. I don't think, and I think, may I suggest that you have a look, for example, at Nobel Prize winner Andreas Deaton's blogs about the fact that that essentially free enterprise economics completely and utterly has eschewed the notion of market power, excessive market power, as a result of which, we're into positions of stark levels of inequality and significant dissatisfaction with the economy. Markets do not work themselves pure. That's why we do need competition. I'm sorry, I'm not going to trust the market. And the second, it drives me absolutely crazy when I listen to the insanely stupid financial press, other than 2 or 3 people in South Africa, who essentially who espouse this nonsense. The bottom line is, markets are always subject to people who, in a sense, accrue greater levels of power and therefore seek essentially to capture rings. It's just the reality of life, which is why, thank God, we have a competition authority. My complaint is not about that, it's how far it goes. But we need to get into our heads the notion, markets need certain forms of correction, and that's why we have competition law. And by the way, one of the most fascinating things around the world at the moment is the debate about how competition law failed, particularly not South Africa, but worldwide, to allow mergers to take place, which have done 2 things. Stultify innovation. Every time some internet company comes along, they get bought by the other large ones, perpetuating greater market power, etc. And quite frankly, that's where the challenge lies. But how do you get the balance right between intervening and ensure that the intervention makes markets work better? I agree entirely. This is not some Stalinist enterprise, which ultimately doesn't start with the proposition that the market is the entity with which we have to work. It's to make it work better that ultimately is a substantial objective of competition policy.
Final question. Patrick, I did promise him.
Thank you. I'm conscious the Commission gets a lot of heat, and I wanted to ask really a procedural question. Firstly, is there a risk, and second, is there something we could do about it, about the whole process of competition inquiries becoming non-progressive, and that it just means too expensive for small firms and small interveners to participate meaningfully. And I'm not throwing any shade at the Commission, because obviously the first thing is the Commission can phone them up and it's almost free to, other than time, to speak to the Commission. But it does seem that in a number of recent cases, participation intervention before the tribunal is quite difficult, and where tribunal processes take longer, are more expensive, subject to discovery, etc. It seems there may be a risk of that being almost unprogressive, and that it's only the biggest firms that can afford to intervene over those long processes. So Bondo, I don't know, I'm not a lawyer, as many of you know, so within the bounds, and you talked about your statutory obligations and timing, are there other procedural innovations that are possible that would lower the financial bar for meaningful intervention by smaller interveners as you go through the process? It may also get to Dennis's court stage.
Sorry, the question is about, are there other processes?
Are there procedural innovations? Basically, have processes become too long and too expensive and too involved that it frightens small interveners who really should be there but aren't? And that's either at the tribunal stage and at the court stage. And I'm conscious that the Commission already reaches out to many of those interveners, but is there a risk that these are effectively not progressing because the process gets so long and expensive?
Yeah, let me answer that in two ways. Perhaps to move away from mergers a little bit. On the question that you raised about small businesses and participation, we know that there were the 2018 amendments, and they've expanded the definition of exclusionary conduct to include also participation by small business. And so what we have seen away from the Commission, because the Commission is always mainly at the forefront in the coal phase, we have been seeing a lot of interim relief applications which start at the tribunal, not at the Commission. The only thing is the Commission has to receive a complaint and then the matter comes to us to ask for interim relief while the Commission is still investigating for the year that it has. So we have seen quite a lot of those types of interim relief applications. Just to give you an example, in 2015 period to 2020, those 5 years, there were 5 intervention applications. 2020 to 2025, and it's not even complete yet, because that's how we do our 5-year strategic plan. We've had 17 interim relief applications. We currently are sitting with about 12 interim relief applications. And we don't have time to go into any of those. Most of them are about small businesses saying we're trying to compete in the market, there is this dominant firm and we are unable to compete. And in most of those cases, we haven't found that it's enough to say I'm a small black business, I'm not able to compete. We have related it to the harm to competition. And so, by and large, those cases have not succeeded. There are a few that have succeeded. And so I'm just trying to give a sense and comfort to say that the key assessment of competition issues, together with public interest issues, is still happening. And on interim relief, the case law speaks for itself. As to interventions in merger proceedings, there is this issue of parties have a right to be heard. Section 34 of the Constitution requires us to hear parties that have something to add. Obviously, the Commission is the first, takes the first bite at all of these competition issues. So our intervention applications, and when we have allowed them, is when there is that extra additional thing that we think a party is going to bring to the table. I'm not sure there's a way of short-circuiting it, but what we have seen it in practice is that sometimes the merger parties agree with the interveners the scope of intervention. That's one of the efficiencies that comes from the process, that we don't hear a full-blown hearing as to intervention. When parties agree it does bring the efficiencies, and that's something that then the parties should consider going forward. And measure parties are normally responsive because they want the measure to be decided quickly, and therefore they come to those kinds of arrangements. Other efficiencies that we'll be looking at is also for more assistance with merger parties and even in prohibited practices. The courts have practice notes which require parties to summarize the cases and specifically point to certain aspects in the record that are important. What we get normally are heads of arguments and a whole wall full of files where you have to trawl through that to find the evidence and to deal with everything. And so some of the efficiencies we'll be looking to do would be to have parties actually file summaries, refers to specific documents, to the extent possible agree issues that are common and that are in dispute. And those are some of the efficiencies that we have been talking about, and in due course we should be able to streamline processes much better once we follow those.
Thank you. In fact, I must maybe apologize to everyone. That was one of the topics we had intended to discuss, and in fact there were a number of other topics we had intended to discuss, but the conversation carried us, and I think it was lovely. So apologies for those of you who didn't get to hear all of the topics on your and our list, but I think we still managed to cover a lot of ground. So I think it remains for me to thank the panel for your insights, for sharing part of the history, for being part of our 25-year reminiscence. It was lovely. I also would like to thank my team, some of whom are here today. We've had an extraordinary we have been immensely privileged to be at the forefront of some of the largest and most precedent-forming cases in this field. It's been an amazing journey, and long may it continue, and I look forward to the next 25 years with all of you. If I have that in me, if we have that in us. But really a heartfelt thank you to all of you, and finally to the audience for attending. I hope you enjoyed the insights. I hope you enjoyed the little walk down memory lane with us, and we look forward to seeing you at our next event. Thanks very much.
May I make one observation? I thought it was unfair to ask these ladies what's going to happen in the next 5 years. With Mr. Trump, I don't know what's going to happen in the next 6 months.